Hi, everyone. Harry here to talk about yet another confusing turn in the Comey case and the question that was front and center at the end of the hearing before Judge Nachmanoff on Wednesday, namely, did the indictment that is in the record, the 2-page indictment with 2 counts, actually get voted on by the grand jury? Or did the government just take the one indictment, the first one that had 3 counts, the grand jury rejected one of them, and just sort of cut and paste and tear off the first and renumber, and then presented it as something the grand jury had voted on? Now, you might think that this overall issue is, as things go in this case, a little bit minor, like who really cares? But first and foremost, the judge and the parties care because this fact came out. People were thunderstruck. And there was the judge actually cited a case that the parties could go to look at. The judge had anticipated this, interestingly, that would give an argument that maybe you can nevertheless count the indictment as okay. But the whole point is he really he brought Halligan to the podium to straighten out just what had happened. Are you saying that somebody took, which would obviously be the way to go that any experienced prosecutor would know, even as weird a situation as this was, that somebody said, okay, we've got a new indictment now. It's got 2 counts. We'll go back to the grand jury. We'll have the court reporter be there and make sure they vote on this one. It looks like that didn't happen, and that's a problem. And that was the state of play as of Wednesday. And it looked, really, again, a terrible mark of inexperience and amateurishness on Halligan's part. Okay, so it was, and that left the question, can they nevertheless take as the grand jury's intent the 2 counts that in the very first vote, when they rejected the count 1, can they take that as what the grand jury wanted to do and just go forward with it anyway? But first is the fact of the matter. Did the grand jury vote on this 2-count indictment? And it seemed like they didn't, which, as I say, is, a really a foolish kind of oversight. And when they went up to court, moreover, Halligan was very kind of unclear to the court. Okay, that was the state of play, looked kind of bad. Now we have government's notice correcting the record. So let me just say, it's commonsensical, but at this point, when you've had this kind of colloquy and discrepancy, if you're coming in now correcting, really recorrecting the record, right? It was a sort of stunning moment when correcting the record, the government had to concede, I guess the grand jury never really even voted on this freestanding actual indictment that we've slipped into the files and is the official indictment against them. Now, though, you go back and you find something is wrong, you just have to, completely play a totally open hand and put yourself, court, we are so sorry. Here's exactly what happened. And they don't do that at all. In fact, I think what they are doing is trying to just make a legal argument that even though the grand jury didn't vote on the actual indictment, you should construe it as if they did. That's a far cry, of course, from saying that they did. But it's a very kind of cryptic document, and it's the only way I think that you can read it to make sense. But if that's so, it's they are really digging themselves deeper and deeper into a hole. So let me summarize to you their notice correcting the record, which, you just expect to see after from the government. The most clear statement of what actually happened in the world, the record, the facts, okay? Instead, here's what they give the court. You can definitely say we had, to the extent it was there, it was suggested that the grand jury hadn't voted on the indictment. The whole notion here is there's the indictment in the file, which has 2 counts, and then there's the 3-count one where they turned down the first. We know they voted on this. And so did they vote here? The United States says, well, the transcript has the following direct exchange. The court asked the foreperson, so you voted on the one that has the 2 counts, the foreperson? Yes. Okay, that sure seems to be the government saying, I know it was all confusing in court on Wednesday, and we got it wrong. So sorry, but never fear. Everything happened in a kosher fashion. The grand jury voted on the actual one. And by the way, that would mean a different proceeding, a court reporter. You would probably have done it the next day. And the whole problem here, that the whole mystery, that the unraveling of which revealed this bonehead move of just trying to, cut and paste and give it to the court, was it was all very little time here, and just didn't seem plausible that Halligan had gone back in and got the 2 counts. And she said she didn't. So if they're trying very much to imply the grand jury voted on it, that would have to have been separate. It wouldn't have been Halligan who did it. She said she didn't. Somehow some other prosecutor went in and got the vote. This certainly doesn't clear it up, right? It just says the foreperson said so, and the U.S. This is so brazen. This sworn testimony, yes, the foreperson alone establishes that the grand jury voted on the 2-count indictment. So either it doesn't, or they're playing a word game. When they say voted on the 2-count indictment, what they mean is voted on the 3-count indictment, and that counts legally as a vote on the 2-count indictment. But that's the whole question. Does it count legally? And here they're coming in to correct the record. And the rest is just more of the same. In fact, it gets, I think, immediately worse and more like the interpretation I'm suggesting. Can't think of anything else. The foreperson said it's the very first count that we did not agree on, and the count 2 and 3, but here we go, were then put in a different package, which we agreed on. So certainly says strongly, the foreperson, that, they took it, they put it in a separate, and it was agreed on. When, how, where's the court reporter? Did this actually happen? And they then continue to have the colloquy from between the court and Halligan. And what it says is, so I assume you want to make both of these pieces of paper, both the 3-count and the 2-count, go in the docket, but you're wanting to make this one the second, the operative one. She says, okay, understood. This confirms the court's recognition that the 2-count true bill is the valid operative indictment. That is not the question. We'll see whether it actually could pass muster, or it could be a mistake that could be excused. But the question is the 2-count true bill one that the grand jury actually saw and passed on, or do we just have the foreperson representing to the court, and she can't speak for the entire grand jury? We as good as did it. And the way it was left is they didn't do it, but maybe that leaves a legal argument. But here, this is a correction of the record, and they have a final little section that says the complete record eliminates any doubt. The foreperson confirmed the vote. So what? The court acknowledged the vote. So what? It just said what the foreperson told them. The court docketed the 2-count true bill as the operative indictment. Yeah, we know that. The question is, did the grand jury see it? Only count 1 lacked concurrence. We know that. Did the grand jury see it? So counts 2 and 3, and this is like a legal conclusion, were true billed by at least 12 jurors. In other words, the grand jury approved. So to me, it's an absolute kind of smoke bomb concealing the facts that became clear as of Wednesday, which is the piece of paper that is in the file was never voted on by the grand jury. That's what Comey's counsel, Michael Dreeben, jumped up to say there's a motion coming about it. They can dispute that motion, or they can say legally it still should be okay. But what they're basically suggesting to the court, and again, in a posture when, man, oh man, you have this big controversy in the courtroom, you better be absolutely 100% accurate to the comma. Instead, I think they're just trying to put the wool over his eyes and suggest that the grand jury sat there and voted out on the actual other indictment that's in the file. I don't think that's going to turn out to be the case. And if that's so, we have a really flagrantly deceptive document and a, really textbook violation of the rule of holes when you're in a hole, stop digging. But they actually are trying to say as a fact, the grand jury voted on this 2-count indictment, and I think, in fact, it's just a total kind of exercise in reconstruing a record that, as it was left on Wednesday, and as I think is the fact, shows the grand jury never voted on the actual indictment. As I say, maybe you can get away with that. Maybe it doesn't mean dismissal, but to come forward and try to claim that actually they did vote on it is both, bizarre and really kind of foolish if they're in fact, and if this is explored more, I think that's what it will turn out, are just trying to kind of pull the wool over the court's eyes. So there you have it. If anything, it may well be, as I've said, that other issues that were explored in court or in the magistrate's opinion turn out to be the judge's focus because they give a stronger basis for dismissal. But this one was absolutely joined, absolutely made clear from questioning from the court that the grand jury hadn't voted on this actual second indictment. That seems to be not only still true, but now they're trying to obfuscate. Just dumb every way you look at it. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.